Attorney Jesse Crisp here, coming to you from Calistoga. And I had a client who we've been representing for a while in a serious personal injury case. We had to file a lawsuit, and we entered what's called litigation. And my client called me and said, what's the difference between a case that's settled out of court versus a case that is in litigation? What do I have to do? And I wanted to explain to you, if you give me 2 minutes, I'll explain to you the difference because I think it's really important. Basically, when you first start a personal injury case, you're in what's called pre-litigation. And that means that the lawyers and the insurance companies can negotiate based on the full extent of your harm and the insurance policies available. If you've heard my videos, you've heard me talk about walking through the 3 doors together. If you haven't, check out the video that talks about the 3 doors. But if a case is in pre-litigation, most likely the case is going to settle. When cases don't settle, it's because either the insurance company is not giving full value, your harm is greater than the insurance policies available, or there's some issue of what's called medical causation, where the insurance company thinks your injuries are actually from something else or not from the issue that their insured is being sued for, the person that caused your crash, or a restaurant where you slipped and fell, or something like that. So in litigation, there are 3 things you have to do, and that's the difference. In pre-litigation, you sign the lawyer's fee agreement, you go and get treated, and that's your only responsibility. But in litigation, you have the obligation to attend a deposition, to do written discovery, and go to a doctor of their choosing. That's called a defense medical exam. So the first step is written discovery. You're going to get information sent in documents that ask you about your background, where you're from, where you grew up, your high school. If you have any type of criminal history, it's very important to disclose that. You always want to, I always say, I can handle anything but surprises. You always want to disclose everything about your history so that your lawyers know about that, or the other side knows about it, because if you don't, you have to verify those discovery responses. They're under oath, and if you're a liar, or if you lied, or you don't disclose it, they're going to say you're a liar, even if you're not. So it's very important to disclose each and every type of incident like that. You know, any skeleton in the closet, you want to disclose those. So if you disclose all that, they're going to ask about work comp injuries, prior injury claims. If you have prior injury claims, disclose them. Disclose. Your lawyers can always handle information if they know it. It's surprises or things that aren't disclosed that look horrible at trial. And that's the point of litigation. You're building the case up to trial. And it may settle along the way, but if you aren't honest about it, or you fail to remember things that happen, that can definitely harm your case. So you want to be completely honest, fill out discovery. Written discovery is the first step. Second step is a deposition, and your lawyer is going to prepare you. We spend a lot of time with our clients preparing them for every deposition so they fully understand the process. And I've done, thousands of depositions myself, and I'm an expert at helping people get prepared for depositions so they're so comfortable, they understand the process perfectly, that they're not ever nervous. And basically that's preparation. So deposition. You go to the deposition, you're giving your statement under oath. The defense lawyer's there to ask you questions. Old school, it used to be in person. Now most of them are by Zoom. Finally, the third thing you have to do in litigation is you have to go to a defense medical exam usually. And that's a doctor that the insurance companies hire. And that doctor is not there to help you. He's not there to treat you. He's there to build a case for the insurance company. So there's a few things that are important to know that your lawyer has to help you understand about that process to make sure that you don't harm your case in any way. And that's it. Those are the 3 things you have to do during litigation. So that's what I told my client today. And obviously, if anybody out there has a case that's in litigation and they're unsure what's happening or what's going on, we often give second opinions about people's cases and the lawyers they have. Or if you have any questions, or you want to file a lawsuit yourself, or have to file a lawsuit, unfortunately, and you have questions, you can give us a call. You know how to find us. Thanks.